All right, John.
Thank you, Your Honor. May it please the Court. Your Honor, the Calhoun County Plaintiffs would also first like to express our appreciation to the Court and all the Court staff for the efforts they've all put forth during the 12 weeks we've been here in the courtroom together. And we'd like to acknowledge also our fellow counsel, both on the plaintiff side and also for the Office of the Attorney General. And many of us have disagreed about different issues, but I think we've tried to do so in a way that reflects the overarching concern that we all have for public education in Texas. And finally, Mark Trachtenberg and I, along with the others on the Haynes and Boone team, Lacey Lawrence, Mike Skidmore, Michelle Jacobs, Adam Sensabaugh, our trial technician Jeff Bennett, and the others who have supported us are all very grateful to our 89 school district clients in the Calhoun County ISD Coalition for the opportunity to represent them in this important trial. We've been in this trial for so many days that it is easy to forget how remarkable this lawsuit is. The elected school boards of hundreds of districts, large and small, have voted to be part of this case, and they all assert that funding for education is not sufficient under the Texas Constitution. Why are they doing this? One main reason is that just under 2 years ago, the legislature decided to cut an unprecedented amount from public education, about $5.4 billion. $4 billion was from the foundation school program, and another $1.4 billion approximately came from grants and special programs that generally target the most disadvantaged children. And a major reason that the legislature was $5.4 billion short of funds in 2000 was that back in 2006, it had mandated that local property taxes be decreased by 1/3, but it had never even come close to making up for the full amount of that lost revenue. Cuts to public education funding of this magnitude had never happened before in Texas. So let's look first at the witnesses who came to this court to say and to testify that the $5.4 billion of cuts has harmed the quality of education in Texas or in their individual school districts, or that funding is below adequate levels. These include 18 superintendents who are in a position to know. They also include experts, including Lynn Moak, whose knowledge of school finance is unrivaled in Texas. And now I want to ask the same question in reverse. In the 44 days of this trial, who has come into this courtroom to defend the cuts, to say that they were a good idea, or even to say that they did not hurt education in Texas? What you see on the screen is not a mistake, Your Honor. It's a blank slide. Because no one came into the courtroom to say those things. Now, what did Robert Scott, the commissioner of the defendant, the Texas Education Agency, have to say about the cuts? He was the commissioner at the time these cuts were implemented. And when the legislature was considering large cuts to both the foundation school program and to the special programs early in the 2011 session, Mr. Scott testified that deciding whether to restore money to the FSP or to the grant programs was akin to asking the guy on the operating table whether he wants his heart or his lungs back. Now, Mr. Scott acknowledged in this case that with the $1.4 billion cut to the special programs, the lungs never got put back, and the heart was only partially put back. Although the cuts ultimately to the FSP were less than first proposed, for most school districts, they still resulted in an average reduction in per-student revenues in the range of 5 to 6% a year. And it's not as though education had been generously funded in Texas before those cuts, either by our own recent standards or in comparison to other states. Even before the budget cuts, districts had been struggling to keep up. And you can see here on this slide an example of what the budgeted revenues for the Richardson ISD look like over the last several years when adjusted for inflation. And this is typical of school districts across the state, not even keeping up with enrollment and inflation even before 2011, and then a rapid drop after. The state's own expert, Michael Pogorski, had done studies in other states showing that Texas was already near the bottom of the 50 states in per student spending. When he adjusted for wage level differences among the states, Texas was already 48 in 2008 and 2009. And that, of course, was before the budget cuts of 2011. So what did these cuts mean in concrete terms? According to Lynn Moak's analysis, we had about nearing 12,000 fewer teachers in our system in 2011 and 12 than we did in 2010-11. That's despite the fact that our enrollment grew by over 44,000 students during that same year. And the results of that show up in individual school districts. Back to the Richardson ISD, for example, where they grew enrollment by almost 1,000 students in that year from 2010-11 to 11-12, but were able to add no new net teaching positions. And the result was that in 2011-12 and in 12-13, the 2 years of the current biennium, they were forced to request over 550 waivers of the state's own 22-to-1 class size requirement for grades K to 4. And as you can see, that compares to 13 in the previous biennium. Now, this concept of state requirements is important because this is where this ceases to be just a debate about policy and it becomes a legal and a constitutional issue. According to the Constitution, it's not enough just to allow schools to keep their doors open or just to get by. The courts have defined the general diffusion of knowledge by referring to the legislature's own standards and requirements. And here we come to the next reason why over 600 districts have come to this court to say that funding is inadequate, and that is the enormous change we've had in our state's standards and expectations. A change which became effective at the very same time as the budget cuts were implemented. The legislature has now set college and career readiness as the mission and goal of the Texas educational system. And that is not just a new slogan. It has resulted in major additions to our curriculum, the new college and career readiness standards, also a major step up in our high school course requirements. And it's also resulted in what Lynn Moak called a quantum leap in our standards for public education. And that's the introduction of the new STAAR end-of-course assessment regime. Now, Your Honor has already heard a great deal about that new system during the trial and in the other closings this morning. And the court knows that 47% of the ninth graders in Texas still had not passed all of the STAAR end-of-course ninth grade level tests, even at the initial phase-in standard after 2 administrations, and were therefore not on track to graduate from high school. That number, by the way, was even higher, as Mr. Moak showed, in some of our state's largest districts. Your Honor is also aware that only a small minority of students are achieving the level 3 standard, in the neighborhood of 17% to 3% in English and math subjects, as Dr. Calhoun showed in his testimony. And level 3, by the way, is the level that was designed in the standard setting process to reflect a high level of confidence that our students were prepared to succeed in college or on track to succeed in college without remediation. And it's the level that Dr. Calhoun identified as the best match to the way our state defines college readiness in our statutes. I just want to emphasize one last point about the STAAR end-of-course system. It's not harder merely for the sake of being harder. The performance levels on the new assessments have for the first time been empirically validated against external measures of college readiness, like the ACT, the SAT, the NAEP, actual college performance in entry-level classes. What's happened is the state has developed a more rigorous system that is designed to be a more accurate measure of true college and career readiness. Even if the legislature at some point decides to change some of the specifics of that system or some of the consequences for not passing the exams, the results we have already show us how far we are from the general diffusion of knowledge as the state has defined it. And it's through that lens that we have to look at the legal question before this court. You've seen this quote already this morning, Your Honor. As the Supreme Court said in West Orange Cove 2, it would be arbitrary to define the goals for the general diffusion of knowledge and then to provide insufficient means for achieving those goals. It would be hard to think of a better illustration of how to violate that arbitrariness standard than what we've seen in the 8 years since that decision. Now, one more difference between this trial and the one 8 years ago is the state's approach to the question of money and student performance. In the last trial in 2004, the state actually presented its own study of the cost of education, and it was a sophisticated statistical analysis performed by Lori Taylor and others of Texas A&M. And one conclusion that that study reached was that, other things equal, there was a positive relationship between expenditures and student performance. The state has not attempted such a study in this case, nor has it done any kind of study of the true costs of public education at any time since this Taylor study in 2003, despite a statutory requirement in the Education Code to adopt rules to calculate the necessary costs on a biannual basis. What the state has suggested in this trial is different. This time, the suggestion has been, despite the finding of this cost study in 2003, maybe more money really wouldn't help. Now, I'm not going to review right now all of the issues, the statistical issues, the methodological issues related to Dr. Pogorski's scatter plots, comparing spending and performance in different school districts. It's enough just to show again what Dr. Pogorski himself said, which is that he did not believe any of his analysis could answer this question of whether there was a causal link between money and student performance. Now, the state might have a better argument on the question of money if it had been able to point to some concrete evidence that school districts are massively inefficient. But the only major feature of our system that we have heard either the state or the interveners claim shows the system is inefficient on any large scale is our method of paying teachers. And if you say that our method of paying teachers is inefficient, you have to say how it should be different. And the only alternative that has been suggested is some form of teacher merit pay. Now, teacher merit pay is surely a policy issue on which reasonable people can disagree. But even Dr. Hanishek, one of its major proponents, acknowledged there is no real research to demonstrate that teacher merit pay will actually lead to better results in practice. And our own experience with a form of merit pay, the career ladder, which was in place for almost 10 years back in the 80s and 90s, was a failure, as Dr. Richard Reedy of the Frisco ISD testified about a week and a half ago. And as Jacob Victor of Duke explained, any workable form of teacher merit pay would almost certainly cost more, not less, than what we're spending now on teacher salaries. Your Honor, I want to frame the money matters issue in a different way. No one in this trial disputes that money spent unwisely will not improve student performance. I think also no one in this trial disputes the proposition that money spent well can and does improve student performance. School districts have never said that more money, regardless of how it's spent, is going to improve student performance. What we do say is simple, and it is that to carry out the measures now necessary to improve our performance will cost money. Measures like the ones that Kay Wagner of Richardson identified in her testimony, like keeping our elementary class sizes down to manageable levels, keeping our teacher salaries competitive to recruit and retain quality people. Measures like providing tutors and extended day and summer school to the tens of thousands of kids who are not passing the STAAR exams and who need extra help. And here is something else that we have shown in this case. When you do a reasonable estimate of how much it will cost to do those things, it exceeds the level of funding available in the system. And that is what Dr. Alan Odden did. Dr. Odden, as the court remembers, is someone who's actually performed analyses of educational costs in other states, and he's done so for governor's commissions, legislative commissions, other state education agencies. And he's also someone who believes, by the way, that many states spend more than is necessary for adequacy. The court heard a full day of testimony about his evidence-based method of estimating costs, and it actually tackles these questions of how many teachers we need, how many hours of teacher and staff time will be required to give tutoring and extended day and summer school for struggling kids, how many librarians we need to make sure our students are reading, what reasonable staffing levels are for campus and central district administration, and what all of that is going to cost. In other words, the very kind of analyses that the state should have been doing but has not been doing. Now, the state has criticized some of his positions. For example, his recommendation of a class size of 15 for grades K to 3 When you combine that with his use of a class size of 25 for grade 4, it averages out to 17.3 for grades K to 4. And that is about 2 students per class lower than what we had in Texas in 2010 for those K to 4 grades. Now, Dr. Auden relies for that recommendation principally on the Tennessee STAAR study, which the court has heard mentioned many times in this case. It's the only truly experimental class size study ever performed. And the state's own expert, Dr. Whitehurst, called that study on the witness stand the most credible and influential study ever performed on class size reduction. So it is hard to see how the state can criticize Dr. Auden for relying on the study that their own experts said is the most credible, influential study of this subject ever done. What I think, though, is equally important is to review again briefly the many ways in which Dr. Auden's estimate was conservative. He did not build in any increase in teacher salaries, despite evidence in this case from Dr. Victor and others that salaries in Texas have not kept pace with overall wage levels in the economy, or even with salaries in surrounding states. He didn't assume any expansion in the current pre-K population. He assumed core class sizes in grades 4 to 12 of 25, which many have criticized him for, saying that number's too high. But even with all of these conservative approaches, his conclusion, when you do the math, was an estimate that we ought to be spending about $824 more per student in average daily attendance than what we were spending in 2010-11. Just for a little context, by the way, according to the National Center for Education Statistics, for the last year of data available for all 50 states, which is 08-09, the United States as a whole was spending $11,339 per average daily attendance, while Texas was spending $93.50. That is a difference of $1,989. So by comparison, Dr. Auden's $824 more per ADA would not even be getting us halfway up to the national average. Now, I want to point out, it's also in the same range as 2 other estimates this court heard. The court heard the estimate from Lynn Moak, who again knows more about school finance in Texas than anybody. And he said that in light of the formula changes and the other reforms he thought were necessary, he believed we needed about $1,000 more per weighted student over where we were in 2010-11. And also, what Mr. Gray mentioned, the inflation-adjusted $3,500 per WADA that Justice Cornyn mentioned in Edgewood 4 back in 1994, when we had much lower standards. That translates today on an inflation-adjusted basis, or rather in 2011, to $65.76 per WADA, which is about a little over $1,000 more per WADA than we were spending in that year. All of these estimates, Your Honor, provide numbers in the same general range. And one thing that's absolutely clear is that all of them are well above where we are today. One more conclusion that is clear from Dr. Auden's work and from other estimates and from the testimony of superintendent after superintendent is that we cannot get to the levels necessary to meet general diffusion of knowledge by taxing at the levels of $1 or $1.04. And the $1.04 is the maximum amount permitted now without a tax ratification election. And that is another reason why the current system is both inadequate and unsuitable, and it's a reason why the system has again evolved into a state property tax. Mr. Moak showed in his report that we have even less local taxing discretion today in the system than we did in 2005, when the Supreme Court upheld this court's ruling that we had the state property tax. And while the state has pointed out that many school districts still tax at $1.04 and not all the way up to the statutory cap of $1.17, we pointed out in response that many of them can't realistically go above $1.04, either because they've attempted an election and it failed, or because they've made a judgment that they won't be able to pass a tax increase. And that is, I would submit, Your Honor, an especially reasonable judgment for many Chapter 41 districts, many of which would pay large amounts of recapture on the extra pennies above $1.04 or $1.06 for some, and would therefore be asking their voters to approve a tax increase when a potentially large percentage of the additional revenue would not even stay in the district. Now, Dr. Wagner of Richardson made this point, so did William Wiggins of Calhoun County ISD, as did Dr. Callison of Eames when they were all on the stand. But we didn't ask the court to rely solely on their testimony on this point, we also performed polls, as the court recalls, in several representative Chapter 41 districts, just to show this effect. And the polls confirmed what the superintendents had concluded, and that is, for many of these districts, the proposed tax increases became insurmountable when the idea of recapture was introduced. Billy Wiggins of Calhoun County ISD said it well. He could neither go above where he is at $1.04 or below where he is at $1.04. And under West Orange Code 1 and 2, that's the definition of an unconstitutional state property tax. Your Honor, I want to say a word about financial efficiency. Mr. Trachtenberg told the court in his opening statement way back in October that he believed you'd hear more in this trial about what unites school districts than what divides them. I believe that has been the case. And we in the Calhoun County Coalition have not claimed that other districts don't need more funding. We agree that they do. And we agree that the whole state is underfunded. We've not challenged the current recapture system or claimed that recapture should be eliminated. All that said, we have some disagreements with some of the positions of the Texas Taxpayer Group and the Edgewood coalitions. I'm not going to review here all of Dr. Callison's testimony or all of the issues related to the financial efficiency claims, including the evidence about how the difference between revenues per WADA disproportionately involves smaller school districts, and which educate on the whole a relatively small portion of our state population. But I do want to make a couple of important points. And the first is, the court should look at the most current data from the 2012-13 school year. None of the numbers or the data or the comparisons that were provided to the court, in this case by Dr. Pierce or Dr. Cortez, were from the 2012-13 school year. The per WADA funding gaps that do exist between districts are considerably narrower in the current year, 2012-13, than they were in 2011 and 12. And that is, of course, because on the whole, the cuts fell more heavily on the property wealthy districts in both years of the biennium, but especially in the second year, when the cuts were targeted or focused on target revenue, as Mr. Wisnowski's presentation here, Exhibit 5653, Slide 152, shows. The 2012-13 data were presented to this court by Dr. Callison. He was the only one who did this. And it showed a significant shrinking of the per WADA funding gaps between Chapter 41s and Chapter 42s on average between the 2 years. Using a constant tax rate of $1 for all school districts, the average differences are reduced by in the range of a third to nearly a half between the 2 years. We've heard some arguments that the 2012-13 data is not yet final, but Your Honor, the formulas and the target revenue numbers for every district that apply to that year are final, and that is, we would submit, what matters. We believe it's essential that the court consider that data from 2012-13, the school year that we're already halfway through today. And my second and last point on financial efficiency is this, and it's that all parties and experts, including Dr. Pierce, agree on one thing, and that is the principal source of the remaining differences in revenue per WADA that do exist in the system is target revenue and the related additional state aid for tax reduction, STAAR. And under current law, target revenue and STAAR expired and are repealed effective September 2017. The legislature has also formally expressed its intent to continue to reduce STAAR between now and then. Without target revenue, as Dr. Callison has shown, the differences in per WADA funding between 41s and 42s virtually disappear. And in fact, differences on a weighted average basis without target revenue show up in favor of Chapter 42s using the weighted average method. I would submit that the court can only make a decision in this case based on the constitutionality of current law. And the sole question before this court on this issue, therefore, is whether anything in the Constitution requires that target revenue be eliminated immediately as opposed to being gradually phased out as it already is under current law. We illustrated the problem of an immediate elimination using the concrete example of the Austin ISD. This is a district that has already been hit harder than most by the recent budget cuts. In 2011-12, it still received about $120 million of STAAR funding. from a total Tier 1 allotment of about $600 million. I think it goes without saying the hardship that would result in Austin by forcing a further cut of this amount, an immediate cut, that anything near that amount, that hardship would be tremendous. And even Dr. Pierce acknowledged on the stand he thought it would be appropriate to phase that out over a period of years. The crucial point is that STAAR should not be eliminated before sufficient funds can be added to the formula system to replace it for those districts that depend on it. And it's only reasonable to allow target revenue to be gradually phased out as it is under current law, even as we would hope fully adequate funding for all districts is phased in. Your Honor, as I conclude, let me just turn back to the idea of the general diffusion of knowledge. It's not the province of this court to dictate to the legislature exactly how much money to spend on education or to make legislative budget decisions. But it is the province of this court, and in fact it's the duty of this court, under Article 7, Section 1 of the Constitution, to ensure that the funding we devote to education is adequate to the purposes our state has set forth in the Education Code, purposes that now define the constitutional general diffusion of knowledge. Now we know the general diffusion of knowledge standard is not perfectly precise, but this court and the Supreme Court in the past have wisely interpreted it as requiring the courts to hold the legislature's feet to the fire. And when the legislature enacts requirements that school districts have to meet, it has to provide them with the means to achieve them, and to do otherwise is arbitrary. It's arbitrary to raise our standards to the highest levels ever while lowering our real per student funding to below where it was 17 years ago. It's arbitrary to impose a class size limit of 22 and then not give districts the resources to hire enough teachers. It's arbitrary to require that students must pass 15 new exams to graduate from high school, and at the same time force districts to cut funding for tutoring, summer school, and extended day programs for the students who will struggle the most on those tests. The general diffusion of knowledge means giving all children a meaningful opportunity, not a guarantee, but a meaningful opportunity to master the state's curriculum, to graduate from high school, and to do so with a level of accomplishment that has prepared them for success in college or in a career. And if we do this, we help ensure that we are developing the skills our economy needs. We also help ensure that we develop the readers, the writers, the critical thinkers, those with knowledge of our history and our place in the world, the citizens that we will need to thrive as a state and a nation. Funding for education is not the only element in achieving these goals, but it is crucially important. And after 44 days in this courtroom and the testimony of some of the most knowledgeable people our state has to offer in the field of public education, the evidence is clear. To live up to its own standards, Texas must do more, and Texas must do better. Thank you.